Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for each service.
That's literally not true.
Is that correct?
I didn't ask you to interrupt me. Oh, for crumb's sake.
Good morning, good Friday morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for joining us this morning. We are we're getting set. Hang on, I'm trying to fix the seats. Just noticed they're broken. Okay, where are we at? There. All right, give them a moment. They'll be working here in just a second. Happy Friday. The weekend is upon us, right? Better be Friday. It was Thursday. I'd be in trouble. Weekend is upon us. Yes, it was definitely Thursday yesterday because I had an amazing podcast last night with Thomas. If you guys missed that, please do catch it on the rewatch. Maybe this weekend if you got some time. That would be great. Love it if you drop a comment there and everything. Seats are working. Please take your seat. That would be the appropriate thing to do right now. Let's see. Pop out chat. There we go. Now we've got chat up here. And would you look at this? Would you look at this? Fire Girl, handmade by Wendy. First in chat this morning. Fire Girl, welcome. I love that your exuberance, your promptness. It's impressive. It's something to aspire to for everyone else. I'm not sure if you know, but being first in chat, somebody has to do it, right? There's always somebody's going to talk first, and today it was you. I'm not sure if you understand. Being first in chat is both a prize, but it has a punishment affixed to it. And so the punishment part, that's where I come in. I'm going to gift you the internet. You think, yay, that's the prize. No, the way it works is really you just get to take care of everyone else's internet problems for the day. You might have already had a little bit of experience with this if you bought an older relative a electronic device, or help them buy something at some point in their life, and then you found out that every time they have a problem with it, they call you because you helped them buy it. It's your fault, right? It's like that, but it's internet wide and it's for everybody. Congratulations, Fire Girl, handmade by Wendy. The internet is now yours, and just make sure you keep it running for everybody, and it will be great. You're going to do great, you really are. And make sure you head over to the shopping page for the low fine of 50 cents. You can download your own copy of internet ownership, suitable for framing and or use as a cover sheet on your CV. Welcome. Happy Friday. We are 2 hours away from Robert Tellis starting. We get to do a little court hopping this morning. I poked around a little bit on the internet amongst our favorite channels. And basically Judge Simpson's doing landlord-tenant things. Middleton's doing landlord-tenant things. And sometimes as fun as those are, they're also sort of depressing. It's people getting kicked out of their house, and sometimes you get some spicy ones that are good, but mostly you just feel bad for these people. And I didn't want to kick off a Friday with that, so we're trying to find somebody else, and I did find one. So we're going to jump to that in just a minute. How close are we to 60K? I think we're like 120 people away. I think 100 somewhere, something like that. It's under 200. With this judge, it'll be 2.5 hours until we start. Oh, there was a car chase yesterday. Let's see. There was the semi that burst on fire. There was the Alfa Romeo. I think there was a little Honda as well. There were car chases all over the place. I'm still trying to figure out YouTube on the car chases because I get demonetized on every single one of them, and I don't know why. I want to figure out what I'm doing wrong. It might be what I'm saying. But I've got to do some tests. So we will have car chases in the future for sure. Probably not today. Missed the entire Tellis trial. Did catch up slightly. Mel Poi. Okay, you need the the opening statements, you need to get those because that'll give you the lay of the land. Then you need skip ahead until Mr. Tellis takes a stand, and then buckle up. Oh my goodness, it was crazy. Mel Stiller, happy Friday to you as well. Welcome. I think we're gonna have some birthdays today. Let me see. There it is. Mama of 3, Babs, Janice, Weezer, Gabrielle, Warrior Queen, and Nikki all celebrating their birthday today. Not sure why my phone was way over there. I can't see it over there. Did Scott see it? Oh, we're live, says Amber. Yeah, Amber, welcome to work. I'm just kidding. Motion to dismiss. Whoa. Oh, that's the Karen Reed thing. We might cover that briefly. There's a big Karen Reed update, so we're gonna look in that. Where's my camera 8 and what is it doing? I don't know. We'll get to that later. We don't need a camera 2 right now. All right, let's get prepared for the birthday song, please, if you would. Do that by standing up, getting a stretch. Roll your shoulders a little bit so you can just free up your chest to take deep breaths so you can sing, full verses. Let's see. I guess we just need to start the music. Everyone join with me. Warm up with me, if you will. La 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 la. There we go. Let's blend your voice with those of your neighbors. Sing out loud so everybody can hear you in the vehicle next to you if you're commuting. Dancers at the ready. There we go. Happy birthday to you. Happy birthday to you. Happy birthday, Babs, Janice, Weezer, Gabrielle, Warrior Queen, and Nikki. Happy birthday to you. Babs, Janice, Weezer, Gabrielle, Warrior Queen, and Nikki all celebrate their special day today. It is a reason to party, not just because it's Friday, but now we have this extra reason as well. Can you consider her late if she's not paid, says Paul Mack. Is Tella still in the stand? Yes. Happy birthday, happy birthday. Here's what I'm planning on doing for your birthday, to these amazing people. First of all, I realize there are a million places you could be, a million people you could probably celebrate with, but you've chosen to be here with us. Privilege and pleasure is all ours. Oh, we have one more? Done. We have one more. Happy birthday, one more verse. We've got an interlude here. Hang on. We're going to sing to Mama of 3 as well. How did I miss Mama of 3? We'll do that again. Okay, everyone, one more verse. So back up at your places. Ready? Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Mama of 3. Happy birthday to you. There we go. Mama of 3, happy birthday to you as well. Help yourself, all of you who are celebrating your birthday today, to free pancakes. It's on the house. Not this house. It's on the other house that makes the pancakes. But help yourself to free pancakes. Denny's. Who else does pancakes anymore? IHOP? It probably should be IHOP at least. But let's see. Anywhere there's pancakes, you should get a free stack. It's your birthday. We have one more verse. There's the drum solo. There's our cue. Everyone get your air drumsticks. We're going to do a big drum solo on the ending. Volume up. That was beautiful. It was beautiful. Beautiful. Excellent job. 10 out of 10 is how I rate that one. The syncopation and the drum solo was just on point. Happy birthday. I hope you have a great birthday. The music has died off, but the celebration should continue. Thank you very much. All right. Let's see. We have a couple things. What do the flashing numbers mean? 5.96 to 6.19 on the screen. That happens to be the data rate in megabits per second that I am uploading to YouTube. And then this one has to do with whether or not I'm recording it's actually 9 different inputs onto this little memory thing. So I'm recording right now, but I don't need to because I'm not showing anything that needs to be recorded. So this is like a status thing for me. This window could probably show it a little clearer, but this window has all my channels. So camera 1 through 8 is right here. And this is microphone 1, microphone 2, and program out, which has audio levels. So I can just make sure. This is one of the tools I use to make sure the audio levels are the right volume for you and not too high, not clipping, things like that. That's just help for me on this corner. If this number right here ever starts going up where it says okay, that's bad. That means it's buffering. That means that my switcher is trying to send stuff to the internet, but instead it's not getting there, and so it's just storing it up inside the switcher, and it can only do that for about, I don't know, maybe 15 seconds before it's like, I'm full, I can't hold anymore, and we just get the spinning wheel of death. You get the spinning wheel of death as soon as that happens, because there's a break in the stream, but it can catch up sometimes. All right. Question about Tellus. So if he didn't take the stand, was State not going to get the "Where are you" bombshell in? Yeah, because the only point that became relevant, really, was when he was describing where he was during the murder, and they knew he was going to go there. Okay, they knew from the get-go that Mr. Tellus wanted to take the stand. His lawyers told him not to, and he was going to do it anyway. And so they knew this was coming in, and he had to basically give his side of where were you during the time of the murder, and his alibi is, I was out for a walk. Well, he was out for a walk. Well, he says he was at home, and then he came home. We've got a text from his wife that he deleted off his phone and off her phone, but not off her Apple Watch, where she said, "Where are you? Bring me my car." Yeah. So that was the smoking gun they dropped, and it was beautiful. It was beautiful. Good morning. What day did Tellus take the stand? I missed it. This is day 3, right? This is day 3 of Tellus on the stand. It's been a long one. Where we are right now, just when we start court, which will be in 2 hours because we're on Pacific time for that court. We are. We've had the direct examination, which is sort of weird because it's not an examination. He's testifying in narrative mode, which just means he sits on the stand and he starts talking. There's no question presented. Tell us about. No, he just starts talking and tells. I guess this story all begins that fateful day way back when I decided. No, he goes out and just tells a story as he wants, and he backs up to the beginning. He's telling a lot about his work. But that's how it begins. That's his narrative form. Once he's finally rested, the state cross-examined him. That was yesterday. We got the cross-examination. The cross-examination, they had no further questions. Now it goes back to redirect. And once redirect is done, that's where Mr. Tellus gets to talk about the few things, the questions that came up he didn't get to answer fully to his satisfaction while the redirect was happening. Then you have recross, where the state gets to ask him a few more things. And I think at that point, unless that cycle repeats itself again, we're going to go to jury questions. And the jury has questions. We know this because at the end of the direct examination, like his narrative speech, the jury's like, hey. And the judge is like, hold your questions, hold them. It's till after both sides are all done. So we know there are jury questions, and they've got to be good. There's probably a big stack of questions. Then it says, Lois Cox wanted me to ask you, did you order the soundboard yet? No, I'm working on it. I have the new switcher. I have to have all the pieces in place, and I want to make sure I've got the switcher that I've picked out, which is almost identical to the one we have right here, but it has SDI ports instead of HDMI. I need to make sure it will work with all the equipment I have. So we're working on that. It's going to require like half a dozen of these little boxes, which is Blackmagic Design micro convertible bidirectional SDI HDMI 3G converter, which just means lots of cables. I don't think we're going to go watch the pretrial hearings just because it gets confusing with him being pro se and things like that. There's lots back there, a lot. We're just almost at the end of the trial right now, so I didn't want to confuse things with that. 2 things we can do. I'm going to jump to court first, and we're going to do a little bit of court hopping. While we do that, I'm going to prep the document for Karen Reed, the breaking news in Karen Reed trial, and then we'll be back with that. Does that work? So let's jump with me, if you will, right into court.
Pay online, in person, or by mail. Okay, is there anything further?
No, and you said I do have a right of appeal?
Yes, you can. On this one, no, because you admitted responsibility, so you have to file a motion to set aside your party admission, and then if it's granted, you'll have to post a bond. Okay? Thank you. Okay, let's see. Patrick's not back. Who's the iPhone? What's your name, sir?
Keith Johnson.
Nope. Okay,
He's not
the
the
person with the hat and it says iPhone. What's your name? He can't hear me yet. Okay, I'm going to call SP 4408950, State of Michigan versus Kevin Allen Bullhuis.
Bullhuis, yep.
Yeah, Bullhuis. I'm sorry, I butchered that. Okay, your appearance, please.
Good morning, Magistrate. Sergeant Stephen James, Michigan State Police Metro North Post.
Okay, and defendant driver, your name?
Kevin Allen Bullhuis.
Okay, well, you were present for the previous hearings?
Yes.
Yes, you heard me lay out your options, remedies, and rights.
Yeah, can you restate the third option?
The third option is to deny responsibility, at which point I swear in the witnesses. That means you're saying you weren't going 86 and a 70. Okay?
16 over?
That says that wasn't me. Then I swear you in and I take the testimony of the sergeant and then of you and any other witnesses, evidence you'd like me to consider. If I find that the state of Michigan has proved by a preponderance of the evidence, that means just a little bit, that you were driving 86 in a 70, then I have to find you responsible and you exit that hearing responsible for the ticket as written, which 16 to 20 over is $200.
Oh,
I don't know the points. And if I find that the sergeant has not met the burden of proof, then I find you not responsible and you exit the hearing with no ticket. So that's all or nothing. There's no in between.
Okay. I guess I'll try option 3 then. And I get to explain my situation or no?
Okay. So if you admit that you were speeding, let's see.
Like to plead guilty with an explanation, but also not be sentenced. Is that an option? Is that option 4? Britt Bottoms, congratulations.
Is number 2 going to just be the easiest option to explain?
No, I can't give you legal advice. So the one, okay, option 2, you were written for a speeding ticket going 16 to 20 over. Okay. And that means going 86 in a 70. And the remarks say that he was going 86. Okay. And that the remarks, Sergeant James, are radar, right?
That's correct, ma'am.
Okay. Can you read the remarks to me just so we can guide this driver? It says PC left lane.
Okay. I suppose this would be the majority of my testimony if we do have a hearing.
No, I just wanted to read what I mean. Vehicle observed left lane passing, closing traffic, and then RMR 86. That's radar, right?
That'd be my patrol car's rear moving radar. So my patrol car was moving. It's radar facing to the rear.
Okay, so sir, this is the thing. So he wrote you up a ticket for 86 in a 70. If you are saying I was not going 86 miles an hour in a 70 mile zone, then you want to deny responsibility and have a hearing. In that hearing, if I find that Sergeant James establishes lays the groundwork for the radar machine, that it was tested and calibrated and accurate, and that the reading was 86, and I find that he sustains the burden of proof by 51%, then you're going to leave this hearing with a ticket for 16 to 20 over, which is $200. I don't know the points. Okay. But if I find that there was something wrong with the radar or that Trooper James did not lay a foundation, then I'm going to have to dismiss the ticket and you'll leave with no ticket. If you admit responsibility, you saw on the first one, fall on your sword, you admit responsibility, what you've learned, how you've conducted yourself. Sergeant James may give you a break. If you kind of don't admit responsibility but not really and have all this argument, as we saw in the second case, he may not be inclined to make a motion. So live and learn what you've observed and make the best choice that you think is best for you.
If you do one, he's pretty much got to give you a break because the judge basically
I'll just do option 2.
Okay, you want to admit responsibility. So if he doesn't like the explanation, or you don't show enough remorse or respect and you're argumentative, then you are going to leave with that. So go ahead. What is the explanation you would like the sergeant to hear?
Start crying now.
All right, Sergeant James, I was leaving work to head back to Ferndale first before heading to Sterling Heights for the appointment. I have a brand new son. He's 4 months old, and he is just going into daycare, and that's what that appointment was for. My wife and I, we've been struggling to get into a daycare, and so this was an important appointment. I believe, well, I did have a question for you as to which.
That's not how it works.
I guess at what point did you detect me going 86?
No, we don't get into that. Okay. Sergeant James is not here on the ticket. He didn't request the hearing, and that's not going to go well for you. So let's rephrase and try.
I apologize.
Try to admit responsibility without arguing.
Okay, so I believe you got me going 86 when I was entering the highway. And then I know that you pulled me over 5 miles later onto Woodward. I pulled over. I was extremely nervous when you pulled me over. I've only been pulled over one other time in the winter going through a yellow, and I have no other points or situations on my driving record. I feel that I'm a very safe driver, but I was probably going a little bit faster than the posted speed limit, and I apologize for that. I ended up being late to that appointment, and I went about looking at the window tints that you gave me a warning for, and I'm in position to get those checked. And again, I apologize that you had to take your time to pull me over.
That was better. You did okay.
Sergeant James, having heard all that, is there anything you would like the court to consider on behalf of this driver?
Yes, ma'am. At the time, Mr. Volhuis was respectful and understanding during the stop. I'd like to offer a reduction to an impeding traffic.
Wow, that is so nice. Mr. Driver, thank the trooper.
Thank you very much.
We tried to guide you. We tried. Okay.
I appreciate that. Sorry.
You nearly tripped over your own ego several times.
So do you admit responsibility to impeding?
Yes, I do.
Okay, that is
Mr. Driver, thank the trooper.
Now. $175. How long do you need to pay?
I can pay today.
Okay, the court gives you 7 days to pay. You can come in line, come in person, online. What's the other one? Mail us a check, but make sure if you pay online, it shows the reduced charge.
Officer,
thank you very much.
I tried to give the officer cash at the side of the road.
Do I still have the language line?
Thank you very much.
Is there an interpreter in the car?
Okay, one more. Hang on. I have 2 more with Sergeant James, but I have one arraignment ready with the is Rogers or Harris on here? Who's the iPhone, gentlemen? Sir, the person with the hat that says iPhone, he can't hear me.
He's asleep. I think he's asleep. His eyes are closed.
Okay. Patrick, how long do you think that arraignment will take? Because I have two with Sergeant.
I will keep my words very, very brief. I'd probably put us at 3 minutes.
Okay. I'm going to have to take that because I have language line. What's the name?
Para, P-A-R. He's probably still in breakout room number 2.
Right. I'm going to bring him. Para?
Yes.
Okay. Sorry, guys. I have to take this arraignment because I have language line.
And then he has a new address I chatted to you.
Okay. We're going to bring them in.
Apparently those translators get paid by the hour, so.
Somehow the gentleman with the iPhone, I can't hear him. Where's that sign?
He took his hat off.
That we show people. Okay, Para is here. Where's the interpreter is here?
They have a sign they hold up.
Okay, is everybody ready?
Let's see what the sign says.
Is it a man or woman interpreter?
This is the interpreter speaking, ma'am. Thank you.
Okay, thank you. Calling case number 2401466. This is the city of Royal Oak versus Rizzo Alexandro.
Put the hat back
Para.
on, sir. Put the hat back on.
Your
please.
appearances, please.
Good morning, Patrick Gagnick. I appear on behalf of Mr. Para. There is an interpreter that is also present. Interpreter, if you want to please state your full name.
The interpreter's name is Fabian Esparza.
Okay, sir, will you raise your right hand? Do you solemnly swear do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications, so help you God?
I do.
Okay. This is the date and time set for the arraignment. Your appearances, please. Interpreter, please ask the gentleman defendant to state his legal name for the record.
Señor, por favor, para el registro legal que estamos tomando, ¿puede decir su nombre completo en voz alta?
Alexandro Parra Rizzo.
Okay, and this is counsel, your appearance.
Patrick Gagnick, I appear on behalf of Mr. Para, who's already identified himself for the record.
Okay, this is the date and time set for the arraignment. How are we proceeding today, counsel?
I spoke in private with Mr. Para with the benefit of the interpreter.
Entonces, estamos aquí para la lectura formal de cargos. Estamos preguntándole al señor Patrick que cómo vamos a proceder. Él menciona que tuvo la oportunidad de hablar en privado con usted, el señor Rizzo Parra, con un intérprete.
Mr. Para indicated he does understand the charge, waive any formal reading, not guilty plea. He is requesting appointed counsel, no objection to proceeding by Zoom.
Él entiende los cargos que se están presentando. Su declaración es de no culpable y solicitó que se le asignara un abogado y no tenía objeciones en presentarse de esta manera por video.
Proceeding via video.
Do we confirm the Kelly Road address?
I texted you his new address, which is on Minot.
Thank you.
Se confirma que la dirección de Cali no es la buena y ya se le mandó por mensaje de texto la de Meetup. Y un momento, por favor. Sorry, ma'am.
That's okay. Give me a minute to put the new address into the ROA. Is this an Operation Drive candidate?
No, all issues have been corrected.
They're not waiting for the interpreter.
Estamos introduciendo la nueva dirección en el sistema y se menciona que todas las situaciones que tenía al momento de manejar ya han sido corregidas.
The court is inclined to set a personal bond. Any objection?
No objection. That's what I discussed with him in private. Mr. Para, you don't have to post any money today. Just make sure you come back to the next hearing.
The court is setting Sorry, go ahead, sir.
Sorry, ma'am. Entonces se está imponiendo una fianza personal y el señor Patrick comenta que ya ha hablado con usted al respecto y que le dice que no tiene que pagar ninguna cantidad de dinero, solo asegúrese de que se va a presentar a la próxima corte. ¿Sí?
Beautiful language.
The court is setting a $2,500 personal bond. No money is due at this time.
La corte está estableciendo una fianza de $2,500, una fianza personal de $2,500, pero no se adeuda nada en este momento.
With the following conditions.
Siguiendo las siguientes condiciones.
He is to personally appear for any exam, arraignment, trial, or sentencing and abide by any judgment entered and surrender to serve any sentence imposed.
Siempre y cuando se cumplan las siguientes condiciones, que él tiene que estar presente al momento de que haya alguna otra lectura formal de cargos, algún otro juicio o alguna otra sentencia, y siempre y cuando se emita algún tipo de penalidad, él tiene que cumplir con esto.
Do not leave the state of Michigan without the permission of the court and do not commit any crime while released.
Tampoco tiene que dejar el estado de Michigan mientras está este proceso en la corte y no cometa ningún otro crimen.
Immediately notify the court in writing of any change of address.
Tiene que notificar inmediatamente a la corte en cuanto haya algún cambio en su dirección.
This matter will be set for a pretrial. The notice to appear will be sent to the Detroit address.
Se va a establecer una nueva fecha para juicio preliminar y se va a mandar la notificación a la dirección que tenemos registrada.
The defendant will have assigned counsel.
El acusado va a tener consejería asignada.
This concludes the arraignment. Patrick, is there anything further? I'm sorry, counsel, is there anything
Nothing,
further
thank you.
requested? Okay, this concludes the arraignment.
Entonces, esto concluye la lectura formal de cargos.
Good luck with the case. You may leave the Zoom. Thank you, Mr. Interpreter.
Sí.
Ya puede dejar la sesión de Zoom. Buena suerte. Thank you, ma'am, for using our services and everyone.
Okay, thank you so much. Both of you may leave. Thank you, Mr. Para. All right, calling SP 4408937. This is the state of Michigan versus Keith Darrell Johnson. Your appearance, please start with the officer.
It's our driver. Sergeant James.
Good morning, Sergeant Stephen James, Michigan State Police, Metro North Post.
Let's see
Thank
if
you for
Keith
giving
learned
me
his
the
lesson.
time to handle that arraignment. I try to be respectful of your time, Sergeant, but I got to take the arraignments first. So thank you so much.
Not at all. I completely understand.
Okay, Mr. James Johnson, I'm looking right at your name. Mr. Johnson, your name, please. Sorry.
Good morning. My name is Keith Johnson.
Okay, thank you so much also for giving me the courtesy to handle that case. Before I go, the gentleman, I gotta send a note to the iPhone, and I can't find, Madam Clerk, I can't find the sign that tells them we can't hear him. I don't know who he is. Okay,
We
Mr.
can't hear
Johnson,
you.
you've been present this morning for the other hearings and heard the explanations that I gave to the other drivers. Do you need me to expand on anything or repeat anything for you? Because I'm glad to do so.
No, Your Honor.
Okay, what would you like to proceed today on this ticket?
Accept responsibility with explanation.
Okay, and what would you like the sergeant to hear about you, sir?
So on the day I received the ticket, I was on my way to work. I was traveling in the left lane, and I was going with the flow of traffic. Sergeant James was in the lane to the right of me, further ahead. So as I was going with the flow of traffic, I was riding my motorcycle, and traffic started to, the other cars that in my lane started to switch lanes over to the right lane. And so I proceeded to go ahead, and I did not realize I was speeding, but I didn't realize I was speeding until I actually saw Sergeant James, and I looked down at my speedometer to realize that I was speeding at that point. So I continued on. Sergeant James proceeded to pull me over. When he pulled me over, I explained to Sergeant James, he asked me, is there any particular reason why I was speeding? I told him that, I'm sorry, but I did not realize I was speeding. I was just, keeping up with the flow of traffic, and I didn't realize it at the moment. So we had a conversation about that on the side of the road. I was very respectful to Sergeant James. My late father-in-law was a police officer, so I am very respectful of the law. And
are you like me and have a panic attack when you're pulled over by the police?
Yeah, well, not really. I mean, I don't get pulled over by the police. I'm very respectful of the law and the laws. So it's very rare that I am pulled over. I haven't had a ticket in over 10 years. This is my third year with owning my motorcycle. I've never had a
That's what makes me the most scared about everything you've said is that you're on a motorcycle. And I think there's just there's been some fatalities recently with motorcycles on our freeways. It's very upsetting. So having heard that, Sergeant, is there anything you would like the court to consider on behalf of Mr. Johnson?
Yes, ma'am. I appreciate Mr. Johnson's admittance of responsibility. I'd like to offer a reduction to a limited access speed 1 to 5 over.
Okay, that's 0 points, but it does abstract. Do you want to admit responsible to limited access 1 to 5?
Yes, Your Honor.
Okay, the court finds you responsible for limited access 1 to 5. That's only one. That's 0 points.
The
though.
judge
That's $130. How long do you need to pay?
2 weeks, Your Honor.
Okay, the court will give you 21 days to pay. You can pay online, in person, or at the in person and at the counter are the same thing. Online or mail us a check. Make sure when you do, it shows limited access 1 to 5. Please slow down.
Baby bear,
I don't want
welcome.
to read about you. Okay, sir. I don't want to read about you. All right, be well. Take care.
Thank you, Sergeant James.
All right, we're gonna turn that off for just a minute because we have a document to read. I've got it all set up here. Well, I've almost got it set up. I can't read chat while I'm doing it, but is it just I sound quiet for some reason. Test 1 2, check 1 2. All right. Let's see. I need a blank screen over here. There we go. That's not it. It was all set up. There it is. I'll bring it over that way. All right, we have a document to view here in the Karen Reed case. Let me just do a couple more things here. You guys able to see that? Perfect. Wonderful, wonderful. All right, this we've been waiting for a ruling from the judge, and it just came down. We have a ruling from Judge Canone. Was it? Is that the right name? Canone? I can't remember if I pronounced that rightly. Memorandum of decision and order on defendant's motions dismissed. Karen Reed moved to dismiss those 2 charges that the jury, they say, actually found agreement on. On June 19th, the Norfolk Grand Jury indicted defendant Karen Reed on charges of murder in the 2nd degree, indictment 1, manslaughter while operating under the influence of alcohol, indictment 2, and leaving the scene of personal injury and death, indictment 3. Following the death of her boyfriend, John O'Keefe, on January 29th, the trial on the matter began in April 2024. There were 8 weeks of evidence and nearly 5 days of deliberations. After the jurors expressed to the court they were deadlocked for a 3rd time, the court declared a mistrial. The defendant now moves to dismiss the charges for murder in the 2nd degree and leaving the scene of personal injury and death, arguing that retrial would violate double jeopardy protections of the federal and state constitutions because the jury, in fact, reached a unanimous decision to acquit the defendant on those charges. Alternatively, the defendant argues the dismissal is required because there was no manifest necessity to support the declaration of mistrial with respect to those charges. After careful consideration, this court concludes that because the defendant was not acquitted of any charges and defense counsel consented to the court's declaration of a mistrial, double jeopardy is not implicated by retrial of the defendant. Therefore, the motion is denied. On June 25th, 2024, the jury began its deliberations in the defendant's trial. In addition to the 3 indictments, the court had instructed the jury to consider 2 lesser-included offenses to manslaughter while operating under the influence of alcohol, involuntary manslaughter and motor vehicle homicide, that's OUI liquor and negligence. On Friday, June 28th, 2024, at approximately 12:10 p.m., the jury foreperson sent a note to the court. It stated, quote, "I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. The court requested argument from the Commonwealth and the defendant as to whether there had been due and thorough deliberation from the jury. Assistant District Attorney Lally, on behalf of the Commonwealth, argued that the jury had not had sufficient time to deliberate and that therefore it was far too early in the deliberative process to give the jury the Tui Rodriguez instruction, which is like an Allen charge. He also pointed out that although the note indicated that the jury had not yet come to a conclusion, it did not indicate that doing so was not possible. Attorney Yannetti, on behalf of the defendant, disagreed with Mr. Lally's characterization of the note, and he argued the word exhaustive is the word that I think is operative here. The jury is communicating to the court that they're exhausted. They've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. You know, this is a case where a jury has the legal instructions. They've only really asked one question, which was to try to get a report they were not allowed to get. And I think the message has been received that the evidence is closed and they won't get anything more. They've been essentially working nonstop over the last 4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they've got nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instructions and go from there. The court ruled that given the length of the trial, the number of exhibits and witnesses, the complexity of the issues, and that the jury had only been deliberating for 3 days, deliberations had not been sufficiently due and thorough to warrant the Tui Rodriguez instruction. It instructed the jury to continue deliberating. On Monday, July 1st, 2024, at approximately 10:45 a.m., the jury sent another note to the court. This note said, "Despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds." The court again requested argument from counsel as to whether there had been due and thorough deliberations. The Commonwealth argued that the jury had been deliberating 22 to 23 hours, but given the length of the trial, number of exhibits and witnesses, and complexity of the issues, they had not done a thorough deliberation up to that point. Attorney Yannetti again had a vastly different view. He argued, "Our view is that it's time for a Tui Rodriguez instruction. They have come back twice, indicating essentially that they're hopelessly deadlocked, but the content of this last message is that they have been over all the evidence. The previous message said they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means. It's a matter of opinion. It's not a matter of lack of understanding. This court, when you send the jury out, encourage them not to take a straw vote. Encourage them to go over all the evidence in a very methodical manner. I think all indications are that they have done this. That this is what Tui Rodriguez is for." The court agreed that the jury had engaged in due and thorough deliberations, noting that this jury had been extraordinary and they had never seen a note like this from the jury. It therefore provided the jury of the full Tui Rodriguez instruction and asked them to return to deliberations with those instructions in mind. That same day, at approximately 2:30 p.m., the jury sent another note to the court. The court stated to counsel that the jury was at an impasse. After the jurors filled the courtroom, the court read the notes. "Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs." After reading this note, the court declared a mistrial and discharged the jury back to the deliberation room to wait for the judge. Counsel remained in the courtroom to discuss an agreeable date to return for a status conference. I want to know what the jury told the judge. On July 8, 2024, the defendant filed the instant motion to dismiss, supported by affidavits from Attorney Yannetti and co-counsel Attorney Jackson. Attorney Jackson's affidavit stated that on July 2nd, a juror in the case, Juror A, contacted him. Attorney Jackson was able to identify the person as the deliberating juror. and based on his or her description of who he or she is, where he or she was seated, and certain identifying information, name and occupation, disclosed during the voir dire process. According to Attorney Jackson's affidavit, Juror A told him that he or she wished to inform him of the true results of the deliberations because he or she believed these results significantly impact the defendant's rights. Juror A said the jury unanimously agreed that the defendant was not guilty of counts 1 and 3, and specifically that the murder charge was off the table. First, Jackson affidavit at paragraph 5. In his affidavit, Attorney Jackson also stated neither Ms. Reed nor her counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. Attorney Unetti's affidavit averred that on July 3rd, he received communications from 2 informants who had received information from 2 deliberating jurors in the case. The first informant, Informant B, sent him a screenshot he or she received from someone else, Intermediary B, of text message that Intermediary B had purportedly received from Juror B. Attorney Unnetti averred that he was able to positively identify which juror was Juror B based on the first name given to him from the informant B. In the screenshot, Juror B texted Intermediary B, "It was not guilty on second degree, and it's split in half for second charge. When the judge sent us back with that Hernandez thing to look at the other side, it turned into a bowling match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose." Unnetti affidavit, paragraph 4. Attorney Unnetti stated that another informant C, contacted him on July 3rd, 2024. Informant C told him that she personally knows a juror, Juror C, and that Informant C and Juror C have a mutual friend, Intermediary C, who is a current coworker of a friend of Juror C. This sounds like a movie plot. That's like 7 layers deep. Intermediary C told Informant C via text message that Juror C was deliberating juror in the case. The Intermediary C had a discussion over text message with Juror C about the experience of being a juror. Intermediary C that said that Juror C said that there layers of hearsay here are crazy. That there was no consideration for murder 2. Manslaughter started polling 6-6 and then ended deadlock at 4 no, 8 yes. Unnetti affidavit at paragraph 10. Informant C texted back, "Interesting. If there was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was confusing." Intermediary C texted, she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. Attorney Unnetti stated that based on the description of Juror C he received from Informant C and the description of what Juror C told Intermediary C, he could positively identify that Juror C was a deliberating juror. Attorney Unnetti later filed a supplemental affidavit in support of the defendant's motion to dismiss, wherein he stated he received an unsolicited phone call from an individual identifying himself or herself as Juror B. Juror B told Attorney Unnetti that he or she was familiar with the affidavit he had previously filed and confirmed the substance of the conversation between Informant B and Intermediary B. Juror B clarified that he or she meant to write, "No one thought she hit him on purpose or even knew that she had hit him." Unnetti supplemental. Attorney Jackson submitted a supplemental affidavit stating on July 8th, another juror, Juror D, contacted him. He identified this person as a juror by the description of he or she is, where he or she was seated, and certain identify. Why do I want to say seated instead of seated? Seated is not a word. And certain identifying information, name and occupation, disclosed during the voir dire process. Juror D told Attorney Jackson that he or she was uncomfortable with how the trial ended. Juror D said that it was very troubling that the entire case ended without the jury being asked about each count, especially count 1 and count 3. Jackson's supplemental affidavit at paragraphs 3 and 4. According to Jackson's supplemental affidavit, Juror D told him that the jury agreed that the defendant was not guilty on counts 1 and 3, and they disagreed solely on count 2's lesser offenses. But they believed that they were compelled to come to a resolution on all counts before they could or should report verdicts on any counts. Juror D believed all jurors would corroborate his or her account. He or she also stated that if necessary, he or she would testify before the court as long as his or her identity remained protected. On July 18th, Attorney Jackson submitted a second supplemental affidavit stating that on July 17th, he was contacted by another juror, Juror E, A, B, C, D, E, that's 5, who he identified by the description of he or she is, where he or she was seated, There it is again. And certain identifying information, name and occupation, disclosed during the voir dire process. Juror E also stated that the jury was unanimous on counts 1 and 3, that the defendant was not guilty of those charges, and that they were deadlocked on one of the lower charges on count 2. Jackson's second supplemental affidavit at paragraph 5. On August 1st, 2024, the Commonwealth filed a post-trial notice of disclosure stating that ADA Lally had received 2 unsolicited voicemails from an individual identifying themselves as a deliberating juror, stating that the jury had been unanimous on counts 1 and 3. The Commonwealth also received emails from 3 individuals identifying themselves as jurors, stating they wished to speak anonymously. In response to the emails, the Commonwealth stated that it was ethically prohibited from inquiring as to the substance of the jury deliberations, and that it could not promise confidentiality as it may be required to disclose the substance of any conversation to the defendant or the court. All 3 jurors declined to communicate further with the Commonwealth. Discussion. The Fifth Amendment of the United States Constitution, applicable to the states through the 14th Amendment of the United States Constitution, and Massachusetts common statutory law, protect an individual defendant from being twice placed in jeopardy for the same crime. The Double Jeopardy Clause affords a criminal defendant a valued right to have his trial completed in a particular tribunal. The defendant is entitled to protection from double jeopardy if there had been some event, such as an acquittal, which terminates the original jeopardy, or if a mistrial has entered without the defendant's request or consent, unless there was a manifest necessity for the mistrial. The interest in giving the prosecution one complete opportunity to convict those who have violated its laws justifies treating the jury inability to reach a verdict as a non-event that does not bar retrial. In her motion to dismiss, the defendant argues that retrial on indictments 1 and 3 would violate the double jeopardy protections of the federal and state constitutions because despite absence of a jury verdict, the jury in fact reached a unanimous decision to acquit her on those charges, or alternatively, because there was no manifest necessity to support the declaration of a mistrial with respect to those charges. After careful consideration, the court concludes that defendant's arguments are without merit. On first one, acquittal of defendant. The defendant first contends that she was acquitted on indictments 1 and 3 and that therefore retrial is barred based on her attorney's affidavits purporting to reflect statements by jurors that the jury reached a unanimous conclusion that she was not guilty on those charges. Although the statements in the affidavits are from purported jurors who wish to remain anonymous, for the purposes of this motion, the court accepts the statements as true and accurate. Even doing so, any agreement among the jurors as to counts 1 and 3 cannot be considered acquittals for purposes of double jeopardy. To trigger double jeopardy protection, an acquittal requires a verdict on the facts and merits. A person shall not be held to account to answer on a second indictment or complaint for a crime on which she has been acquitted upon the facts and merits, and the only verdict which can be received and regarded as complete and valid verdict of a jury is an open and public verdict, affirmed in open court as a unanimous act of the jury and in presence of the whole panel, so that each juror has an opportunity to express his dissent to the court in case his decision has been mistaken or misrepresented by the foreman or his fellows, or in case he has been forced into acquiescence by improper means. Okay, so what I think this is going to do, I think, first of all, this is going to get appealed. It's going to be appealed to the Supreme Court. And I think the Supreme Court's going to side with the defendants on this, because, and I think the result is going to be that forevermore in Massachusetts, the process of questioning a jury will be changed as a result of this case. I think this is going to be instrumental in changing those final instructions or the interaction with the jury. The verdict shall be unanimous, shall be great. The general verdict returned by the jury to the judge in open court. The jury shall file a verdict slip with a clerk upon the return of the verdict, such as the weight of final adjudication cannot be given to any jury action that is not returned in a final verdict. And a distinction must be made between an agreement on a verdict and return, receipt, and recording of a verdict. Because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted of any of the charges. The only unanimous act of the jury here was their representation to the court that they were at an impasse and unable to agree on whether the Commonwealth had established beyond a reasonable doubt the elements of the charges. The purported later attestations by some jurors, after they had been dismissed, that the jury had in fact agreed on some of the charges during deliberations do not have the force of a final verdict. The case law was that after a mistrial was declared due to deadlock, judge did not err in refusing to accept signed verdict slips recovered from the deliberation room showing not guilty, because it is not enough to show the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. Double jeopardy did not bar retrial after a hung jury where foreperson reported unanimous vote on offense before deliberations had concluded, but deadlock at conclusion. The defendant argues that it is elevating form over substance to not accept the statements of the affidavits to reflect an acquittal of the defendants on counts 1 and 3. However, the rendering of a verdict in open court is not a ministerial act, as the defendant contends. Rather, it communicates that the finality of the deliberations and its pronouncement in open court ensures its unanimity. Public affirmation in open court provides safeguards against mistakes. Indeed, the authority upon which the defendant relies places particular importance on the jury's pronouncement of its findings in open court. And we've got some case law arguing that forewoman's announcement in open court that the jury was unanimous against conviction on capital and first-degree murder was an acquittal for double jeopardy purposes. Thus, a verdict in substance is a final collective decision reached after full deliberation, consideration, and compromise among the individual jurors. And when that decision is announced in open court, it becomes entitled to full double jeopardy protection. Declining to give the effect of the verdict received from the lips of the foreman in open court would elevate form over substance. Where there was no verdict announced in open court, here, retrial of the defendant does not violate the principle of double jeopardy. I think the fix here that I think the Supreme Court may institute if they take this up would be that if a jury comes back and says hung, that each of the jurors are polled as to if that's the case. Does that make sense? Because all the other jurors apparently thought, hey, we have an agreement on this, and the foreman said we can't reach this. Now, the foreman may have had a misunderstanding as to how the jury form worked, which it appears that maybe that was shared amongst the jury. But I think if the jurors had been polled as to whether they were, beyond all hope of reaching a agreement, that this might have come out. The second argument, the manifest necessity of mistrial. The defendant's motion to dismiss also argues that double jeopardy bars re-prosecution because she did not consent to a mistrial and there was no manifest necessity to declare one. This argument, too, is without merit. A defendant's consent to a mistrial removes any double jeopardy bar to retrial. Consent may be explicit or implicit. Explicit consent may occur by either moving for a mistrial or agreeing to one. Consent to a mistrial may be implied where a defendant had the opportunity to object to a declaration of mistrial and failed to do so. Where the defendant sits silently by and does not object to the declaration of a mistrial, even though he has a fair opportunity to do so, a court may presume his consent. A court may infer consent only where the circumstances positively indicate a defendant's willingness to acquiesce in the mistrial order. A court may infer consent only where the circumstances positively indicate a defendant's willingness to acquiesce in the mistrial order. Where is that demonstrated? Where did they demonstrate their willingness by the Tui Rodriguez instruction? Is that where she's getting that from? Consent to a mistrial need not be expressed, but may be implied from the totality of the circumstances attendant on the declaration of a mistrial. As noted, the court here declared a mistrial after the jury reported 3 times they were deadlocked. After the second time, the court determined the jury had engaged in due and thorough deliberations and gave the Tui Rodriguez instruction before sending the jury to deliberate. Massachusetts law provides that if a jury, after due and thorough deliberation, returns to the court without having agreed on a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew the law applicable in the case, and send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent, unless they ask from the court some further explanation of the law. If, after due and thorough deliberation, the jury twice advised the judge they were unable to reach a verdict, the judge may not properly send the jury out again without their consent, unless the jury ask for some further explanation of the law. In their note to the court, the jury specifically stated to continue to deliberate would be futile and only serve to force us to compromise deeply held beliefs, making it clear they would not consent to continuing their deliberations. Attorney Unetti twice argued for the court to give the Tui Rodriguez instruction, the final step before the court would declare a mistrial. Let's see, counsel's request for Tui Rodriguez in the case law permitted the inference that both parties were provided an opportunity to be heard on possible alternatives to mistrial. Okay, so that's where she's drawing it from. Specifically on Friday, June 8th, after 3 days of deliberations, when the jury sent their first note indicating they had engaged in exhaustive review of the evidence and had been unable to reach a unanimous verdict, Yannetti argued that the jury had engaged in due and thorough deliberations, was at an impasse, and should be given the Tui Rodriguez instruction. The following Monday, when the jury sent a second note, iPad was dying, sorry. When the jury sent a second note, where are we at? After deliberating for approximately 2 hours, stating that consensus was unattainable, Attorney Yannetti again argued that due and thorough deliberations had occurred and described the jury as hopelessly deadlocked. Defense counsel, in arguing twice that due and thorough deliberations had occurred and pushing for the instruction, presumably was aware of the legal implications of the jury if the jury returned deadlocked again. Nevertheless, in a remarkable turnaround, defense counsel now argues that the result they twice advocated for was sudden and unexpected. See defendant Karen Reed's motion to dismiss at 8. Although the court did not specifically ask defense counsel if they had any objection to the declaration of a mistrial, counsel had multiple opportunities to voice an objection if they in fact had one. While waiting for the jury to enter the court, after the court announced jury was again at an impasse on the afternoon of July 1st, defense counsel could have asked to be heard on the issue. During the subsequent discussion about scheduling a status hearing right after the court declared a mistrial, counsel had yet another opportunity to inform the court of its dissatisfaction. Lastly, counsel could have communicated to the court any objection or request to poll the jurors while the jury was still at the courthouse waiting in the deliberation room after the declaration of mistrial. Instead, defense counsel has said nothing to the court about the mistrial and then proceeded to the courthouse steps where Attorney Jackson declared to the media and onlookers that the Commonwealth failed miserably and will continue to fail with its prosecution of the defendant. She didn't like that. It strains credulity to believe that if the defense counsel wanted to voice any objection to the court, it would not have been heard. Significantly, defense counsel were no shrinking violets. Neither Attorney Jackson nor Attorney Yannetti has ever needed this court to inquire whether counsel had an objection in order to be heard. This is a subtle jab. They are loudmouths, and they'll let you know if there's a problem. And the court has never denied counsel the opportunity to be heard in open court or at sidebar. I thought she did at one time. I thought there was at least one time where she said no. The court reconvened many times at counsel's request. Just days before the declaration of mistrial, defense counsel asked to address the court while the jury was deliberating to raise an objection about the verdict slip. Attorney Jackson was not shy in informing the court that he wanted to make his argument and that the court's decision about the verdict slip was not how it should be, and it's over our strong objection. Attorney Jackson went so far as to suggest that it was almost like this court is directing a verdict of the subordinate charges by not making changes he wanted. The court finds it hard to believe that when counsel heard that the jury was in the impasse for the third time and a mistrial was inevitable, at perhaps the most crucial point in the trial, counsel would sit silently if they did not consent to a mistrial. As such, the court does not credit Attorney Jackson's advertment that he lacked an opportunity to be heard. Defense counsel's silence, despite ample opportunity to be heard, is deemed consent. When trial judge on its own, this is case law, on own initiative declared mistrial, defendant's silence was deemed consent, and there was ample time to object despite not being directly asked by the judge. Silence was not consent, where judge's conduct was so intimidating to defense counsel as to foreclose any objection from defense counsel to the declaration of a mistrial. Even assuming arguido that the defendant here did not consent to the mistrial, the law is clear that the retrial is permissible so long as there was manifest necessity for the mistrial. The trial judge's belief that the jury is unable to reach a verdict has been long considered a classic basis for proper mistrial. Let's see, also describing a hung jury as a protocol example of manifest necessity. Because the court here had no doubt, based on the jury's notes to the court, that it was unable to reach a unanimous verdict, and the jury represented to the court that continued deliberations would be futile, there was manifest necessity for the mistrial based on the deadlock. As stated above, the foreperson on behalf of the jury in this case sent the court 3 notes, none of which indicated agreement on any of the charges. In the first note, the jury wrote that they had been unable to reach a unanimous verdict. In the second note, they stated they were deeply divided by fundamental differences in our opinions and state of mind, and that consensus is unattainable. In their third and final note, after they had been given Tuya Rodriguez instruction, the jury stated that they continued to be at an impasse. They described themselves as starkly divided, and their perspectives on the evidence explaining. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Okay. I think this part here, I'm thinking about the jury. And yes, the jury came back without a verdict, right? They were hung. But the instructions they were given made them think they had to. Is that not a problem? Because now Karen Reed is, presumably going to face these same 3 charges again, and she has to convince another 12 jurors that she's not guilty of charges 1 and 3. I don't think that's right. How many juries do you have to convict if the instructions are poor or not clear? And the instructions to the jurors, the jury form, was a point of contention. The only reasonable interpretation of these notes, and specifically the final note, was that the jury could not agree on any of the 3 charges and further deliberations would serve no purpose. That's the only reasonable interpretation, was they could not agree on any of the 3 charges. I disagree there because of the confusion of the jury form. For the defense to now claim that the notes were susceptible to different interpretations, such as the court should have inquired further, rings hollow, particularly where Attorney Grignetti had twice argued that the jury had engaged in due and thorough deliberations and could not agree. In declaring a mistrial, the increasingly adamant manner in which the jurors announced that they were deadlocked, moreover, defense counsel's conduct immediately after the declaration of the mistrial in no way suggests that they thought otherwise. The defendant contends that the court failed to carefully consider that as an alternative to mistrial, it could have simply asked the jury to specify the charges on which it was deadlocked. We saw this in the cold case, the hot tub cold case. Defendant Karen Reed's motion to dismiss at 8, however, the question whether the mistrial is appropriate in the circumstances of a given case is not answered by the application of a mechanical formula. There's case law on the decision whether to declare mistrials within the discretion of the trial judge. Rather, the court considers several factors such as statements in a jury's note concerning their inability to reach an agreement, the time spent in deliberations, and the length and complexity of the trial. More case law, we have never required a trial judge before declaring a mistrial based on the jury deadlock to force the jury to deliberate for a minimum period of time, to question the jurors individually, to consult with or obtain consent of either the prosecutor or defense counsel, to issue a supplemental jury instruction, or to consider any other means of breaking the impasse. That's some strong case law there on the state side, on the Commonwealth side. Where here, the jury had been deliberating 5 days, had returned to the court 3 times stating they could not agree, had been given the Tuya Rodriguez instruction, and returned hours later with a note plainly indicating they could not agree as to the elements of the charges, and that to continue to deliberate would be futile, asking the jury on which charges they were deadlocked was not necessary to determine that there was a manifest necessity for a mistrial. More case law says where a final note from the foreperson unequivocally stated that the jury were unable to come to a unanimous decision, the judge was not required to inquire whether there was any reasonable probability of unanimous verdicts or if the jury would consent to further deliberations. The judge did not err in other case law in declining to poll a jury on whether further instructions or deliberation would be likely to resolve a deadlock. Case law is not looking good for Karen Reed, I'll tell you that. Moreover, the defendant argument ignores the fact that one of the 3 charges had lesser included offenses. Therefore, if upon questioning the jury had indicated to the court that they were not deadlocked on all the charges, the only option would have been for the court to send the jury back for further deliberations. Judge should not inquire as to partial verdicts on lesser included offenses. Such action would be improperly coercive under the circumstances. It has been repeatedly recognized that deadlocked juries are particularly susceptible to coercion. Where the jurors have twice reported themselves deadlocked and have already heard the Tuya Rodriguez charge, a judge's inquiries concerning partial verdicts cannot avoid communicating to the jury the judge's desire to salvage something from the trial. where here the jury had had before in it one indictment, which included lesser included offenses, had 3 times reported themselves deadlocked on separate charges, had already heard the Tuya Rodriguez charge, and had sent a final note indicating that continued deliberations would only serve to force them to compromise their deeply held beliefs. Sending them to deliberate further would have been improperly coercive. But they didn't ask. I think the right thing to do was not to send them to deliberate again, but to say, is there anywhere you have agreed? That's the question that she could have asked, that we saw in the hot tub cold case. It's the court's view that under these circumstances, even posing the question to the jury of whether they actually were deadlocked would have implied to the jurors that the court wanted them to resume deliberations to reach a verdict. But you wouldn't send them out. Given that Attorney Jackson had already expressed concern that the court was directing a verdict of the subordinate charges, the court was extremely cautious to not give any appearance of partiality. The defendant's argument suggests that questioning or polling jurors who report a deadlock is best practice, or at least commonly done by trial judges. We've seen it. However, the defendant has not cited any cases saying as much, and indeed, such an inquiry is not undertaken in the regular course. For a judge to make such an inquiry of her own accord could impede upon the strategic decision of counsel to not make such a request. The defendant's argument is based upon hindsight. No one other than the jury knew that the questioning of the jurors as to their deadlock would have yielded a favorable outcome for the defendant. It is likely for that reason defense counsel consented to this court's declaration of a mistrial. Post-trial inquiry. The defendant alternatively requests that the court allow counsel to conduct a post-trial inquiry of the jurors to substantiate the existence of an acquittal. Defendant Karen Reed's motion to dismiss at 9. Such an inquiry is impermissible. Defendant's argument relies solely on Commonwealth versus McCallop. In the McCallop, the Supreme Judicial Court held that the trial court should have allowed the defendant's motions for jurors' names and contact information based on the post-trial statement of a deliberating juror regarding racist statements made during deliberations. The Supreme Judicial Court explained the presence of even one juror who was not impartial violated a defendant's right to trial by an impartial jury. Recognizing that racial bias in the jury system is a familiar and a recurring evil that, if left unaddressed, would risk systemic injury to the administration of justice, McCallop Court held that defendants should have been given a fair opportunity to obtain an affidavit from the jurors setting forth some specificity who among the jurors made statements reflecting racial bias, and the statements that were made. The defense argument here does not implicate racial bias or her right to receive an impartial trial. Thus, the reasoning the court employed in McCallop does not extend to this case. Declining to extend racial bias exception to inquiry of jury unanimity because infection of the criminal justice system with racial or ethnic bias is a unique type of constitutional deprivation that requires a vigilant response not warranted in the circumstances presented here. The defense request, YouTube just tells me now's a good time to play an ad. I don't think so. The defendant's request effectively seeks permission from the court to inquire from deliberating jurors that which is impermissible, information regarding the substance of jurors' deliberations. I don't see that. This is a stretch to me. The secrecy of jury deliberations has served as a bedrock for our judicial system, and an inquiry to the jury's deliberative processes would intrude improperly into the jury's function. It is simply not the case, given the content of the jury's final note to the court, that any inquiry to the jurors now could be limited solely to the results of the deliberative process and not implicate the process itself. I don't see that. Any inquiry would necessarily require the court to understand why the jury's final note communicated a deadlock on the charges when post-trial certain deliberating jurors are purportedly stating that the jury was in fact unanimous on most of the charges. While the defendant contends that the conflict is relative to the fact that the instructions given to the jury by the court were confusing, determining whether this is true would necessarily require inquiry back and forth among the jurors during deliberations. The judge is precluded from inquiring into the internal decision-making process of the jury as a whole on the individual juror being questioned or the individual juror being questioned. Accordingly, evidence that jurors misunderstood the instructions of the presiding judge cannot be considered. Thus, such an inquiry is prohibited. The defense counsel has not cited one case suggesting the post-trial inquiry they now seek is appropriate or that it could change the outcome of the proceedings. For the reasons already discussed, an acquittal of the defendant now on indictments 1 and 3 based on conclusions purportedly reached during the jury's deliberations is not possible. Therefore, there is no reason for the court to allow post-trial inquiry of the jurors. Case law says no error in denial of motion to subpoena the foreman where process would only serve to impeach jury's report to the judge in open court. The conclusion and order. This court recognizes that the bar on retrials following acquittals is perhaps the most fundamental rule in the history of double jeopardy jurisprudence. However, there was no acquittal on any of the charges in the defendant's first trial. There is no risk of subjecting the defendant to double jeopardy by retrial on all the charges. Therefore, the defendant's motion to dismiss is denied. Signed, Judge Beverly Cannoni. Wow. She had some jabs in there. She had some jabs. Let's go back to chat really quickly if we can. Wrong way. Where did chat go? There it is. All right, I might have missed a few comments. Let me check really quickly. I think I did. Samantha Terry, welcome. Welcome to the jury. Thank you for your continued support. 19 months, Samantha. That is awesome. Britt Bottoms, ready for more narcissism today from Tellus, member of the jury for 7 months. Thank you very much, Britt Bottoms. Mathis Grease. So the jury reached a verdict in substance, but doesn't count because they were dismissed before they had the opportunity to say it. What a farce. Mathis, congratulations. Thanks on 8 months. I think there's something here. I also think that possibly the Supreme Court might reject this because there was never a jury. They don't have the evidence that what the jury members that have come out unspoken is true. If they had that, the whole jury unanimously came out and said, yes, that was our verdict. We just couldn't agree on that last one, and we thought that's what the instructions were based on the instruction from the court. Then you've got a fault of the court, right? You got 12 reasonable people who are told by the court how to do something, and they try to follow it, and it's wrong. Wouldn't that be a reversible error of some sort? Colleen Elizabeth, welcome to the gallery. Thank you very much. Love the blue courthouse. Thank you for your support. Queen Olive didn't expect anything different from the judge. Appeals court will overturn this. It's going to go to appeals. I think it will probably go to Supreme, actually. I'm sure the defense has their appellate draft ready and waiting for her order to come in and to add anything relating to the order itself. They're drafting it right now, I think. Chat is not on the screen. Chat is now on the screen. Sorry about that. I need to put a couple messages up here. There we go. Samantha Terry, thank you very much. 19 months. Britt Bottoms, 7 months. Mathis for 8 months. And Colleen, welcome very much to the gallery. Love the blue courthouse by your name. We have, time-wise, we've got just over an hour before Tellus comes in. Let me check some of our old favorites and see who's up and about in court today. Let's see. Cedric's still doing landlord docket. Okay, let's see who else is up. Judge Clark. He's doing some criminal hearings. That might be interesting. He's down in Florida, right? In the Panhandle area.
Yeah, Mr. Myers, come on up.
Mr. Myers.
Madam Clerk, don't mind me calling one off the afternoon docket. I got a couple waiting.
I don't imagine she will. If she does, we'll have a conversation.
It is Friday. I haven't been hollered at yet, Judge.
We'll talk her into it.
I'm due.
I'm due a hollering.
First one that we have is State of Florida versus Amanda Nichols. In that case, I was speaking with Ms. McAfee. I don't think there's an objection to leaving it on. We've been doing kind of a deep dive into this one to try to get it resolved, but okay. I don't think she objects to leaving it set.
All right, we'll leave it set on the September 3rd trial docket.
I'm sure it's September 3rd.
Yes, ma'am.
Oh, I thought, yeah, September 30th. We'll leave it on that docket. Do you want to set up another trial management on the September 20th, or is there any need?
We can do that, Your Honor. That way.
September 20th at 1:30 for the trial management.
Next one is State of Florida versus Stephen Slagle. And in talking with Ms. McAfee on this one's a little more involved. I think that the agreement is to continue this one. There was a Slagle, S-L-A-G-L-E. You want to set this for October?
I think November is the next trial docket.
November trial docket? We'll set it for November 4th at 8:30 and October 25th at 1:30 for a trial management. Take it off that trial, the September 30th trial docket. 20th at 1:30. I mean, October 25th, excuse me. 25th at 1:30.
The last one that we have on the trial calendar for this afternoon, State of Florida versus John Gonzalez. That's Mr. Sullivan's case. I don't, we can leave it set, but I don't know how high on the priority he's going to fall. He's out of custody.
Mr. Sullivan?
John Gonzalez.
He's pretty low on the list.
You want to you go ahead and put it on another trial docket?
That's fine with me.
What's a realistic trial docket? October of 2025?
I was going to say, do you want a realistic answer to that? I was going to say April or May, but realistically not by the end of the year.
Okay. Why don't we set it for, is it January 6th? Is my trial docket in January? I think it is.
Yeah, January 6th. That doesn't sound real, Your Honor, when you say 2025 out loud.
That's next year. Only 9 months, as Nicole Wise. Feels like
yeah,
forever.
We'll set it for
Thanks
December.
Thank you very much, Nicole. Thanks for the kind words. Thanks for being part of that. Wouldn't be
probably
the
17th, 18th, 19th, 20th. 20th at 1:30 for trial management. Maybe I'll have something figured out by then.
Yes. It's all the easy ones I got for right now, Your Honor.
All right. Ms. Nelson, if there's any coffee left, I could use a cup of coffee.
Soundbite.
Recall Mr. Hockaday.
Mr. Hockaday? Yeah, you're already back.
Mr. Hockaday, if you want to come back up.
Hetzler.
Or sorry, Hetzler.
Mr. Hetzler.
I'm sorry.
That's okay.
Mr. Hetzler. Again, this is case number 224916. And I believe the state has had a chance to review the report.
Is the state prepared to go forward with the competency hearing?
Yes, Your Honor.
And are you satisfied with the report from the Florida State Hospital? I see Ms. Piper. Are you?
Yes, Your Honor. We'd waive the necessity of any hearing.
And I have reviewed the report prior to coming to court, and I'm prepared to find that Mr. Hetzler is competent to proceed at this time. If you could just prepare a simple order to that effect.
Yes, Your Honor.
And we need to set him for another hearing date.
If we could, Your Honor, whatever is closest, it's technically a violation of probation. I spoke with the state. They're going to be preparing an offer.
Let's set him for September the 18th at 9 o'clock for a preliminary VOP hearing.
Sounds like they're just scheduling stuff. Nothing really exciting. I will tell you, this morning I was watching a video from Brian Steele. He's the Young Thug attorney, the one who got handcuffed and put in the lockup, arguing before the Supreme Court on a question where a grand jury indictment was done incorrectly. And it was spicy, man. I would never want to argue in front of a Supreme Court. You start like halfway into your opening sentence, and they hit you with like a punch and a question, and just aggressive. It's nuts. It was pretty good. He was nervous. You could see he was very nervous to do that. It was a little bit longer, else we would have viewed it today. But
all right,
this judge has either he's eaten or he's got a whole big wad of big league chew.
Let's see, is Mr. Warner out? See, Ms. Nelson, if Mr. Prince or Mr. Can't think of the other name. Middleton.
I'm just saying he looked pretty chill, Dale Mox. Yes, it was from a couple days ago. He looked pretty chill, arguing in front of the court. But compare that to how he argues in the Young Thug trial, and it was a very, very different Mr. Steele. Hell to you, Alicia. Alicia, thank you very much. I love that. It's a fun little typo we have here on the channel. We just dropped the O. Hello, welcome. 1:30 a.m. Winding down for the week. We've got, I tell you, if you can stay up all night long, we've got a party in store for you today. Yes, Supreme Court, they know it. It's a panel of the smartest judges in the area, and they're Supreme Court justices for a reason. They're very good judges. They know the law very well. They understand the implications of decisions. And what I love about them is almost every single Supreme Court asks everybody tough questions. And so, like the person that interrupts you during your opening statement and hits you with a question just right in the gut, will then do the exact same thing to the opposition and flip. And sometimes they'll ask questions that support you and help you out. It's crazy. It's the dynamics of a Supreme Court argument are just really fun to watch. It's so good. It's so good. This is Judge Clark. He's in, I think he's in the Panhandle area of Florida, if I'm not mistaken. Yeah, it's the standard procedure, but there's the way they ask it. It is the most confrontational of any interaction, like sanctioned by the rules of court. I kid you not. They just go at each other's throat sometimes in a polite way, very informed, polite way.
How about that? That's like a Alexa.
It's a quiet day in court here. Let's see. Oh, he got his coffee. Judge is happy now.
That's like say, Ms. Nelson, please. Y'all waiting on me?
Yep.
I'm ready. Yeah, you may. I appreciate it. I appreciate it. Ooh.
There's a couple of wildlife boards that are meeting right now, if you're into hunting and fishing. Let's see. Wichita County, I believe that's in Texas. Their commissioners are meeting. I don't think it's very spicy. There are only 11 people watching that one.
Oh, crazy.
I just want to be as tall as her.
What are we waiting for, Judge?
I'm just so short.
No.
I have not been fishing since I got here.
It's something I realized for a while. I just
Yeah, I should have. I covered for a
Can't help
long
myself.
time, and that was fun.
Who's this? Ms. McCarthy?
Are we ready?
Well, Your Honor, I had a witness who's out of town that I was going to call for Mr. Frazier's case, but I think I'm just going to go forward with that one. So.
All right, let's call Mr. Warner real quick. Then we'll do. Mr. Milton's joined us. All right, Mr. Warner is at the microphone. Mr. Middleton?
Your Honor, so this matter is currently set for a trial on the 3rd. There is a possibility, there still is a plea possibility in this case. Mr. Prince and Mr. Sullivan have been working on it and communicating. They do need to probably speak again. But that's where we are.
Do we want to leave it on that trial docket?
Yes, Your Honor. I have spoken with Mr. Prince a couple times. I would like to reach a resolution. Realistically, I don't know that that's going to happen. I'll continue to try. But I've sent subpoenas out, and I'd like it to remain set for that trial date.
We'll remain on that trial docket, and we can resolve it that morning. We can resolve it that morning. If not, we'll pick a jury. Okay?
Sounds good.
Thank you,
Your
Mr.
Honor.
Middleton.
Thank you, Your Honor.
Pick a jury.
And are you ready, or are you waiting, Mr. Myers?
We can go, Your Honor.
Mr. Myers has a fantastic beard.
Okay with him. This is Mr. Bobby Sheffield making his way to the podium, Your Honor. He had arraignment scheduled for earlier in the week, and it was continued to today because we had a motion to reduce his bond. And so after we do the motion to reduce his bond, we'll need to give him a new date.
Okay.
Handle that arraignment part. Your Honor, in this case, the total bond that was set in this case is $500,000, $250,000 account.
Whoa.
There has been an information filed, one second-degree felony and one third-degree felony. I would say, based upon the charges that have been filed against him, that $500,000 bond is too high, Your Honor. I'd respectfully request that bond be lowered to $50,000 on each count. And what I would do to support that, Your Honor, is Mr. Sheffield is a mechanical. He does mechanical and industrial plumbing, and he was working at Tyndall Air Force Base. He does live in Arkansas, but he has retained our firm. We've been in contact with him, obviously, at the jail and his family in Arkansas. I have no reason to believe he would not avail himself to the jurisdiction of this court. He was down working at Tyndall, which tells you something about his past. He doesn't have a criminal record. He was cleared to work on the Air Force Base. So given that, I don't think he's a flight risk, and the intent of the bond is to make sure he does appear as directed. Given that, I think $50,000 for each count would be appropriate.
Mr. Sullivan?
No, I've got no objection. I think $500,000 is a little excessive in this case.
What I'll do is I'll grant the motion, set a $50,000 bond on each charge for a total of $100,000.
Wow.
I'd like for him to go ahead and sign a waiver of extradition.
Yes, sir. That won't be a problem.
Since he's doing that, if he makes his bond.
That means he will agree to get pulled back, so Florida can pull him back from Georgia if they need to.
We'll go ahead and once he signs that waiver, you can go ahead and arraign him. We'll set him a pretrial date.
What about these charges are that started at $500,000?
James, how you doing today? You should be somewhere else this morning, as nice as it is.
Bailiff's
you know
tired.
that? You know where we should be too, don't you?
Fishing.
Your Honor, I'll submit a short order for the bond. As far as the arraignment goes, there has been an information filed, so I believe we filed a written plea of not guilty on his behalf. Given the nature of the charges, probably October. It'll take us October to get the discovery. And
is he pretty sure he's going to bond out?
My understanding in speaking with his family is that they would be able to make that bond, Your Honor. If something happens and they don't, obviously
I'm going to set him for October 24th at 9:00. That's our in custody. But if he bonds out, we'll set it for the it'll go to the October 10th. Excuse me. Where's my October date?
10/25?
October 15th.
15th.
But what you'll do, you'll need to make sure you keep your mailing address current and stay in touch with Mr. Myers. You understand? Okay. All right.
Yes, that's okay. Contact you.
Tumwater Troy forwarded on some stuff to me. Day on the Docket put out
Tell you what, he's
update on Franklin Tucker. That's the Treehouse trial.
He's a better boy.
It looks like he's back to being pro
Do whatever he
se.
tells you to do. Wherever
And
he
he's
tells you
looking
to
for
go.
help to send out subpoenas.
Friday, got a Sunday in church on Sunday morning. Walked
September 6th, trial's canceled.
He stayed busy.
Next calling is October 15th.
I'm proud. He's Daddy didn't do that. But he's a lot better than his daddy. And like I say, that's the son of my mom.
I just read it on the Twitterverse, Ashley.
I'm proud of it. Smile, Mr. Sullivan.
Smile.
I said smile.
That's an order.
How long were you?
Hey, Lord.
He had already got it. Yeah.
Your Honor, I think I've accomplished everything I could.
Well, I appreciate your help today.
But we'll be I'll be back this afternoon, I suppose. I was hoping we'd have people show up, but they'll be here this afternoon.
I'll be here too, but it won't take us long.
It shouldn't.
Is there nothing to do in that court on a Friday morning? Mary, I still need to get. I need to brush up on what happened. I know it's sensational, a lot of drama right now, but I don't know as far as the actual proceedings where they're at.
Ms. McCarthy, you ready on the Mr. Frazier?
Yes, sir.
That's why I watch
This
NASCAR.
is a motion to suppress evidence, and I've just reviewed the motion, or I've reviewed the motion prior to coming to court. Is it the state's burden to go forward?
It is, Your Honor.
Okay.
Motion to suppress evidence.
The essence of the defense motion is twofold. One, there's insufficient. The confidential information provided by the informant in this case was insufficient, and that the law enforcement's probable cause to stop the defendant based on him having a suspended driver's license was inaccurate. I'm not even going to address the confidential informant part of it because the law enforcement essentially had more than probable cause to conduct a traffic stop and arrest the defendant for driving with a suspended license. I'm going to essentially stipulate to the facts as alleged by Ms. McCarthy in the motion that law enforcement found that he, did a search through databases, found that he had a suspended license, saw him driving, and then arrested him for that. Her contention, the defense's contention, is that they ignored the fact that when he ultimately was arrested, he had a valid Texas driver's license. That notwithstanding, I'm going to introduce into evidence, State's Exhibit 1, a certified copy of the defendant's Florida driving record, which on page 2 reflects that as of 2020, his driving privilege in the state of Florida was in fact suspended indefinitely, which is consistent and corroborates what the facts that law enforcement had and the facts that's stated in Ms. McCarthy's motion. The state's argument is essentially, regardless of whether Mr. Frazier was able to go to Texas and receive a valid driver's license in Texas, his driving privilege was suspended in the state of Florida. And the fact that he was seen by law enforcement driving was more than probable cause to place him under arrest. Ultimately, the contraband in this case was found on his person pursuant to a search incident to arrest.
Ms. McCarthy?
Yeah, I'd like to call Mr. Frazier.
All right. Frazier, raise your right hand.
Do you swear the testimony you should give on this issue, showing the truth, the whole truth, nothing but the truth?
Yes, ma'am.
Okay, please state your name for the record.
Jeremy Frazier.
Okay, Mr. Frazier, your license in Florida was suspended. Did you know that?
No, ma'am.
Okay, did you have a license in Texas?
Yes, ma'am.
Is this your license?
Yes, ma'am.
Okay, I'd like to introduce him to evidence.
No, I'll say one thing.
And then Mr. Frazier would like to address the court.
I would like to address the court because, okay, I can explain my, when I got the same document, I think that's the same document that you have about my license suspended. I looked over it and I had forgot that that I supposed to, let me see when this was. I don't know if it was in 12 or 13. I know you probably can see it. I was sentenced to Department of Correction for driving on suspended license for child support. I went to prison down here, they gave me 18 months. And during that time, you can see in the record book that that Texas had a hold on me for possession, for a possession case. They gave me 10 years in prison. And they gave me 10 years in prison in Texas, DOC. And I went to the halfway house at work, and that was I working on my CDLs at the time when I was even when I got arrested. So that's why I was kind of confused when they said that my license was suspended when I got here. And also, Judge Bank, I ended up, I don't know what year, when I think it was 2021. Because that was my first time coming back to see my daughter here. I called a DUI. And Judge Van told me to prove to him that I had Texas driver license. He said nothing about my license suspended. I was on probation down here. I had to go to Judge Van. I had to bring my license to court. And I had to prove that I took the DUI class, for him to drop it down to reckless driving. And he dropped down to reckless driving because I proved that I took the DUI class that you go to, and so that I had a license.
Dwayne, thanks for your generosity.
And he
5 memberships.
Does it matter?
I had to pay a $1,900 fine. That's how.
I guess the question I had: does it matter?
Well, Your Honor, it matters in a way because they don't know if he had knowledge of it or not. Without knowledge, it's a.
I understand
it's
that.
It's a ticket.
But
still probable cause to
it's
stop.
Still probable cause to stop someone is a question.
Your Honor, I would also point out the defendant, arguably, he just testified that he went to prison for driving with a suspended license. That shows that he did have knowledge.
But the reason my license on there because it's a civil suit because I didn't pay the restitution fine. Whatever the restitution was.
We're not here on a driving on license suspended or revoked case. We're right here on a probable cause to stop someone
for drugs,
for driving on license suspended or revoked, and then the search, and then if they're arrested, the search instant of that.
Correct, John.
And that's the question.
That is the question, Your Honor. And they didn't ask him if he had a license. They didn't do anything. They just cut him out of his seatbelt and took him out of the car.
And Your Honor, may I state the court, please?
Sure.
Okay. He said in his statement, Your Honor, I don't know if my lawyer going to play the deposition tape. In his statement on deposition, he stated that, and also on the paperwork that you're looking at, he said he surveilled me 21 days before to know that I didn't have a driving license, right? Okay. Also, in that same deposition where Mr. Francis Sullivan was at, he stated my previous counselor, Mark Merritt, asked him, okay, is the CI and the confidential source the same person in that case that you talk about in your sworn statement for arresting Mr. Frazier? He said, yes, sir, that's the same person. So how did you learn about Mr. Frazier how did you learn about Mr. Frazier? He said, I learned about Mr. Frazier through the confidential source. But I can show you right here, he said on the sworn statement that he ran me in 21 days prior to find out I had no license. You know what I'm saying? But right here, Your Honor, I have proof, and you can get this to the Your Honor if you want. I have proof right here, the same person who sought me up, the same address that they give you, that he went into this, she can play the deposition paper, that he admitted that he found out about me through this dude that sought me up. I have a paper right here that shows I got locked up 7/26/2023 at 3 o'clock. That's when he said that they arrested me, right? I got the paper to show 7/26/2023. That's the day that at the same time and the same date that he busted the dude house that set me up.
Okay.
You see what I'm saying?
Yes, sir.
So he lied. I have all the paperwork right here. He lied saying that, oh, we didn't know. I found out that Mr. Fraser didn't have a license, so we was gonna lock him up. But I can prove right here, if you want to see this paperwork, that he found out about my license, Your Honor, after they had incarcerated me. I can prove to, if you want to see this paper right here.
What I'm gonna do is I'm gonna take it under advisement. I'll set it for September 19th. I'll have a written order. You'll have a written order by that time. Okay? All right, that'll conclude today's hearing.
Judge.
All right, Mr. Dennis.
Don't think he's getting anywhere
this
with that one.
afternoon. Would you like to call him?
I do have one this afternoon. It's Caleb Seegers, and I was hoping to maybe resolve it now. This is with Mr. Sullivan, and we spoke earlier through email. We don't have a plea agreement. We're kind of set to move forward. My understanding from Mr. Sullivan is he doesn't expect it to go on the 30th. So I don't know, Your Honor, if you just want to keep it on there and as we get closer, deal with it, or go ahead and move it forward.
Mr. Sullivan?
I'll defer to the court on either.
Do you think it might be resolved on the September 3rd?
Based on the email I got from Mr. Dennis this morning, no.
Okay, well, let's just set it maybe for the January 6th at 8:30 for a trial, and December, was that 20th? For trial management, Madam Clerk?
Yes, sir.
And then if there's a resolution, y'all can place it you can advance it on one of my dockets.
Okay. Thank you for taking my case early.
Yes, sir. Have a good weekend.
Thank you. You too.
Yes. Take it off 1:30 and take it off September 3rd.
I'm sorry, on Mr. Fraser, what date did you give him?
September 19th at 9 o'clock for a pre-trial. All right. Anything else this morning?
I have, well, that may have already been continued. Donnell Brown. Is that?
Let's see.
It may have already been removed, Judge. I don't see.
It was yesterday afternoon. Mr. Peters is in Chicago.
That's it. That's all I have for.
All right. Well, adjourned. I'll see y'all.
They're adjourned. I want to show you this letter from Franklin Tucker really quickly. If we can go there. To whom it may concern, it's dated the 11th. It's an older one. My name is Franklin Tyrone Tucker, and I am a pro se inmate who needs to get ready to go back to trial very soon. I'm writing the clerk office because during my first trial, I was not incarcerated and could request the clerk's office to issue subpoenas through the e-file system. There was a very nice supervisor who helped me make sure I got my subpoenas for trial last time, named Katie. Hopefully, she or someone else there can tell me how to request subpoenas for my witnesses so that now that I'm in jail. Do I make a subpoena for each witness for you to issue, or just give you their info with the time and date to appear and have you fill out the subpoena? If someone could get back to me with the process, that would be great. Thank you all so much. Franklin Tyrone Tucker. And you can see he's in custody in Key West, Florida. So he's looking for help getting witnesses there. This is one of the problems being pro se, especially if you're pro se in custody. It is very, very difficult to work this system. There's nobody who's going to jump up and be like, "Oh, I'm in the department of helping pro se people. You know, that's my job description." There really isn't. There isn't somebody out there, unless the court decides to be kind to you and cut you a break, and the prosecution might help or something like that. We'll see what happens with him. Hopefully he gets his witnesses called. Since when has he become incarcerated? Macy says, oh, that's cool. What happened there? What button did I just push? I need to know because I need to unchange it. I'm like floating in this. This is a cool view. This is a pretty cool view.
Call from Mr. Wisconsin.
Ivan, well, I try to figure out what I did to my computer here. What's on your mind today?
Well, I just wanted to chime in on the last defendant. First of all, I didn't understand any of the story. It was just too convoluted. But I would like to say I am not in favor if, in fact, his license was suspended for unpaid child support. I am not in favor of that. Okay, that creates a whole smorgasbord of issues. Okay, I understand people need to pay their child support. Okay, you got to take care of your kids. Lord knows, but you take away a man's right to drive, to go to work, to pay his child support. It's like, it just seems counterintuitive to me. I'm also not a fan of taking away.
It's not taking away his right to go to work so he can pay his child support. It's taking away his right to go to work to drive in the state because he hasn't paid his child support. Because driving is a privilege in the state, right?
How's a man supposed to get to work to pay his child support if he can't drive? You know, how are you supposed to go look for a job? How are you supposed to go to interviews? It just creates further criminality for yes, that is a crime to not pay your child support. That is an offense, and you should be held responsible in some way. But I just don't understand how making it harder for somebody to do what they didn't originally do solves the original problem.
Right. It starts a vicious cycle, is what it does.
And that's why they always say it's way easier to get in the system than it is to get out.
Yeah.
And it just creates a further criminality that doesn't have to exist.
What would you propose, considering the deadbeat dad? Because look at it from the mom's point of view. Okay, the mom. Let's just make up a scenario. The husband's cheated on her, decided, hey, life's better on the other side of the fence, left, and filed for divorce. She's now she was a stay-at-home mom. Now she has to get work. She has to pay for child support. She has to pay for child care while she's working. How does she, if the dad is no longer in the picture, is not paying his share of the child support? What ways can the state enforce that?
I'm not necessarily against jailing people for unpaid child support, because one thing that jails, at least in Wisconsin and everywhere else, as far as I know, have are work release programs. So you know what? You don't pay your child support, you go to jail, you put them on a work release, and you start garnishing their wages. And for everybody who's saying, take a bus, take an Uber, take a Lyft, guess what? A huge, vast majority of this country doesn't have. Like, come up to where me and Libby are from and try to find yourself an Uber. It doesn't exist, okay? You want to ride your bicycle 25 miles to get to the plant, to go to work? I mean, those options aren't... I understand this may not be in that category, but those options aren't necessarily available in every aspect of the country. So you can't just say use public transit that doesn't exist.
Isn't jail a more drastic measure than just revoking their right to drive?
I don't believe so, because if you're in jail, many of these jails now have programs set up. You wouldn't believe how many factories around here, and I understand where I am isn't everywhere. I know that's anecdotal, but I'm just saying that there are lots of places that want to hire guys who are on work release from jail. Guess why, RA? Why do you think they want to hire jail guys?
Because they'll pay them less.
They know they're going to show up to work.
They'll pay them less because they know they need the job too.
Yeah, right. They don't have to. Right. They're going to be there. And you start putting people, you take away their license. Now guess what every person I've ever met who's had their licenses suspended has still done? Drive. They still drive. Okay.
Yes, we see them in court on a regular basis.
Right. Okay. That's why I mean, it just furthers the criminality. So you aren't exactly, you aren't solving the problem. You're just creating a deeper embedded criminal, if you want to say that, because every time you drive and get caught without a license, it becomes more and more severe. So now, not only are you not paying your child support, but now you've got fines out the wazoo for driving without a license, and on and on and on. And this is why people don't get out of the system, is because it is sort of created and manufactured in a way to sort of, in my little county here, I live in a county that probably has 30,000 people in the entire county. Okay. It's not big. Our county jail probably recycles there's probably 50 to 100 people in that jail at one time. It recycles the same 300 people on a revolving door year after year after year. And
recidivism rates are insane in the jail system. It's crazy how many times people go through the system.
Yeah, it's the same people who don't have anything, who've never had anything. And are there exceptions to the rule? You bet. But it is the same revolving door of the same people who have drug problems and alcohol problems and mental health problems. And it is just a bleeding of those who have nothing. And instead of saying, hey, how do we stop this? They aren't in the business of stopping it. And when I was, helping out with halfway houses for people who, were getting out of jail and getting out of prison and getting out of institutions, we went and proposed a counter to jail where they could come stay in a halfway house. And one of our biggest selling points is it will save the county so much more money instead of putting people in jail than to put them in halfway houses. And you know what they said? We're not interested, because all they hear when they hear saving money is less officers, less jobs. And so God knows I don't have all the answers, but I do know furthering the criminality where it doesn't have to be isn't the answer.
Sorry, we're spying on some kids. I'm blurring their identities, but they're stealing sand from the park, apparently.
You can't steal sand. It comes from the earth. Okay, sand is for everybody.
This is from a volleyball pit. That's where I'm going to go metal detect right now. We've blurred their identities to protect them. Future criminals at work right here, using that Home Depot bucket.
Those kids are going to be somebody someday, okay?
They're probably going to sell it on the street corners, what I'm thinking. Sand, $5 a cup.
Did you ever have a lemonade stand?
Oh yeah.
Yeah?
Did lemonade stand.
I'm the kind of guy who walks by the lemonade stand and puts a 20 in and doesn't take a cup.
Oh, who doesn't?
I appreciate
who doesn't? That's first of all, nobody wants to drink the lemonade anymore, right? I would much rather they sell like bottled Gatorade, right? That I would pay $20 for a bottle of Gatorade from a lemonade stand way faster than I would drink a 25-cent cup of lemonade stirred with somebody's grubby fist that maybe washed today and maybe didn't. But at the same time,
I would much rather give those kids a 20 and go give that lemonade or Gatorade or whatever to the people who are actually thirsty. That's the way I see it. There are people, and even in our little town in God's nowhere, Wisconsin, has people under a bridge and in the park and everywhere else. And, take your $20 and go give $20 of lemonade away. That's how I see it.
Right.
But all right, I'm going to be very disappointed in you if you go 45 days in Utah without casting a line. Okay. I'm going to be very disappointed, sir.
Do you know how much it costs to go fishing as a non-resident in the state of Utah?
I heard $49.
Yeah. For 3 days.
Well, You've gone 0 days. 3 days sounds like an excursion. Okay,
the problem is I have zero fishing gear. Zero. Like I own nothing.
If I give a $50 super chat, I'll give a $50 super chat right now
to get me go fishing.
If you promise to go fishing in live stream, okay, that's the deal.
Okay, I'm thinking I head down to Walmart. I get the cheapest rod and reel pre-strung bait casting thumb spinner child's pole possible. I put a worm on and maybe a salmon egg and cast out. Head to Farmington Pond. I think I'll go to Farmington Pond in Farmington, which is a little tiny pond stocked with fish every Saturday, and live stream that, catching some planter trout. What do you think?
All right, I'm going to send a super chat for the fishing license right now. Okay,
Zebco for the win.
Then you will have no excuses. And I expect a video. Those are my terms.
Yeah. All right. I'll tell Mrs. R.A. that we've got to adjust the schedule because fishing just became a priority.
Yep.
All right.
Yep. It's part of the business plan now. So
fishing poles at Walmart are $9.99. There we go. I think I'm going to get a Walmart fishing pole. It comes pre-strung with like 2-pound test line, which spools up on you the first time. You get a backlash the first time you cast every time. But I'm thinking maybe like a Barbie pole. You think do a Barbie fishing rod or maybe the Lightning McQueen one? I'm not sure which one would be better.
Look for an Avengers.
Oh, that's for the big fish.
Yeah. Yeah. I'll have you know, all right, I'm nearby, and so is Libby. Not to dox anybody. She's been pretty open about it. We are from an area where the Muskie Hall of Fame is. So if you ever want a real treat, You come up to northern Wisconsin and you can tour the Muskie Hall of Fame.
Muskie scare me.
You've never seen anything like it.
Muskie scare me.
Never seen
They're
anything
all
like
teeth. It's an alligator without legs is what you've got there.
Hey, you'll never have a more exciting cast in your life than if you snag a muskie. Okay.
Ayden, we are just a few minutes away. I think we're about half an hour away from the
right,
Robert
sir.
Tellis trial starting. Good to talk to you, my friend. Appreciate you. I'll try to go out fishing.
All right, love you guys.
We'll see you. Love you, man.
Yep.
Bye.
Bye.
Love it. Ayden's great. We'll see if we can go fishing. And I guess. Secondhand store. I can get good quality stuff for cheap. Thinking I can go down to the thrift shop, get some thrift shop fishing gear. But that's a hot commodity. It moves pretty quick. It's like a good golf club. When a good golf club comes in, I mean, it's not there for long. It's out of there. All right. I guess there's going to be very little sands left to metal detect in the in the volleyball pit whenever I get out there. Should have had out there last night. We are about half an hour away from the start of the Tellis trial, which means we're 15 minutes away from the start of. Was that right? Are we an hour and a half? Hold tight. Let me check my math here. Robert Tellis. Okay, we're half an hour away from the start. So if we take a 15-minute break, we can portal over there. They're starting at 9:30. You're right. Everyone sorry, thank you. Everyone said. Oh my goodness. Ivan just sent a super chat. It says fishing license. Fishing license. There we go. Now I have no excuses. Use a string. I would do this in a heartbeat. I wind a line around a little pole, throw it out there with the bobber. Guys, we're going to do this. I'm going to go. Oh, man. I want to do it from Farmington. I'd love to take you up to like where I grew up fishing. Like I could take you to where I could take you guys to where the bomb happened, the whole bomb story. I can take you up there and show that. Let's plan this. I think we could do like a double header. I could show you where I found a bomb, and if I haven't told you the bomb story, I'll tell you that eventually one day. Where I found the bomb, where it exploded, where the damage to the fence is. I think all that stuff is still there. I haven't been there in years. We could do that, and then I could also show you where I grew up fishing. Use a pole with string for line and a hook attached to it like we did as kids. Okay, so I've got to get the fishing license. A string on your metal detector. Now we need to see you fishing. I will tell you, when I fish, I do it differently. Generally, people, when they see me doing it, they say, that's not fishing. That's catching. That's because when I fish, I catch. Other people fish and don't catch. But I'm big on the catching part of it. I'll send you some gear, said Blackbird Squeaks. Oh, I'm good on gear. We can pick some up at Walmart. I'm thinking, here's what I'm going with. I've already got it envisioned in my head. I need 8-pound test, which is enough that you can free a snag without snapping your line. I need some snelled eagle's nest. I think they're called eagle's nest or eagle hooks, maybe number 8 with leader. I'm going to do with Balls of Fire brand salmon eggs, green label, and I need some removable split shot. So I'll do 1 or 2 split shot leader Balls of Fire salmon egg, and then either cast it out just on a reel, or I don't even think I need a pole. Fishing live stream on the schedule. Maybe if we reach a verdict right away, we might have this afternoon to do it. No, I can't this afternoon. I don't have a car. My family left me till tonight. I have nothing. Maybe I can call Enterprise and get a rental, have them deliver it to me. Stephanie says $5 for bait. I can dig my own worms. Maybe the kids will out there in the volleyball pit will let me borrow the shovel so I can dig some worms. If you ever went noodling, yes, Mary. I got bit. I got bit by a trout and it ripped open my finger. Because apparently the noodle was quite effective. Me wiggling my fingers, it looked like a worm, and it got me. And I said, I'm done with noodling. RA is living the life. I could Uber. I have never Ubered in my life. I don't know how I could do it. Now you got money for license and money for bait. I want a fishing stream. Take us with you, says Iris. Okay. Yes. But you guys have to realize that this is probably going to be in place of court one day. It was a trout bite in the little stream I grew up next to in Davis County. All right, so we're gonna wrap up. Now I'm excited about fishing. We're going to wrap up the live stream here. We are going to portal over to the Robert Tellis trial, which is going to start here in the next few minutes. I've slated it to start in about 10 minutes, so we'll have that ready to go for you. It's going to be a crazy day. We're starting on redirect. Mr. Tellis is going to have his notes, 72-point crayon notes. I guess grease pencil notes, and he's going to answer a few questions, fill in some details that the prosecution did not let him get to on cross. It should be very brief. I'm thinking about half an hour at tops with Robert Tellis on redirect. After that, recross, and then jury questions, which is what we're all here for. I cannot wait for that. That's going to be amazing. It's going to be epic. And I think we're going to have closing statements today. Closing arguments. I think it's got to happen. Lizzie Dog says, lures and fishing bling. Get the good stuff. Ivy says, some cash for Filet-O-Fish in case you're not successful. Stop by McDonald's. Get yourself some breaded fish. Oh my goodness, you guys are the best. Thank you very much, Ivy. I'm going to be successful. It's in my blood. How could I miss? Maybe I'll take you to a good spot. Maybe I'll take you to where I nearly died on the Weber River at the waterfall. That is beautiful. It's a beautiful spot on the river. Okay, well, we'll get this figured out, guys. We'll do that. Tonight, when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again in just a few minutes as we prep for the Robert Tellis trial beginning at 9:30 Pacific. That means 10:30 Mountain, 11:30 Central, 12:30 Eastern. I think I got those all right again. These time zone things are just, I'm learning it. Now we need proof. You guys, we'll see you in a little bit. Have a good one.